Hi, I'm Mark Mifflin. I'm a member of the Illinois Defense Council Legislative Committee. It's April 29th, 2019, and I just want to give you a brief update on the action of the legislature. Because we're entering the final month of the legislative session, the legislature is scheduled to go home at the end of May and finish the spring session. And then the governor will consider those bills that they have passed over the summer, and then the legislature will come back for the veto session sometime in November, October, November, in that area. Those dates have not been set yet. But there are 4 bills of special concern to the Illinois Defense Council that I wanted to bring to your attention and tell you what the status is. The first is Senate Bill 1596. It's a trial lawyer bill, and it provides that if an employee's claim, work comp claim, is barred, or occupational disease claim is barred by the statute of repose, which is 25 years, before the disease manifests itself, then that employee can jump out of the work comp system and file a claim in court based on those injuries, the disease. This bill is intended to cover mesothelioma cases, but it will apply to other cases too, where there are latent diseases which are not discovered and do not manifest themselves until after the occupational disease statute of repose has run. The IDC strongly objected to this bill as it progressed through the Senate. It did pass the Senate, and I'll tell you in a minute, but it does breach the exclusive remedy provision that has been Illinois law in employee-employer relationships for over 100 years. It also exposes the employers to unlimited damages like any other common law case. These would include punitive damages, which we think is a breach of the agreement as to how to handle employee-employer relationships in the work comp system. Another argument we used was that the statute of repose has a purpose. Everybody acts like the statute of repose is a bad thing and it bars these claims, but it's intended to protect the rights of all of the parties because there are no records, even memories are lost. 25 years is a long time to try to defend a case. The other point that we made, which is a pretty good point I think, is that there may be no insurance for the employers under these circumstances. The general liability policies provide that they don't cover employee-employer disputes, and the work comp policies provide that they don't cover cases in court. So there's a dichotomy there. It just may not be covered, and that to expose the employers to that type of a claim would, we believe, be unfair. The trial lawyers are also likely, if this passes, to apply it retroactively, so that's something else we'll have to watch for, and the IDC will be on top of that. It's probably unconstitutional to apply it generally across the board to cases where the statute of repose has run before this bill passes, because the Doe versus Diocese of Dallas case is a priest case, but it says that a defendant has the right to rely upon the expiration of the statute of repose or statute of limitations, and once that is done, it cannot be resurrected at that time. So the bill has passed the Senate, like I said. It is currently in the House. We expect it will pass the House and be placed on the governor's desk sometime probably within the next couple of weeks, so before the end of May certainly. So Governor Pritzker is likely to sign that, but we will continue to work against the bill, including talking to the governor's office about that. Another bill that we are working very hard on that's still pending is House Bill 2233. This bill, as filed, would eliminate special interrogatories. And we all know that special interrogatories have been effectively used to test general verdicts on specific questions that arise, particularly about causation or some affirmative defenses. Right now, the law is that it's mandatory for the court to give a special interrogatory, and the answer to that special interrogatory is controlling over a general verdict. The bill has been amended purportedly to soften the bill and to make it better, but it will have the same effect of effectively eliminating special interrogatories. Our objections to that were, what the bill does now was that the court will have discretion to give special interrogatories instead of requiring them mandatorily be given. If there is a contradiction between the general verdict and the special verdict, the court will be able to instruct the jury about that inconsistency and send them back to deliberate further on that. And then if there's still deadlocks, the court would have to declare a new trial. There's no way that the special interrogatory would be allowed to control the verdict as it does now. And the most troubling part of this is that under the bill as amended, attorneys would be able to discuss the impact of the special interrogatory answer in their closing arguments to the jury. So the plaintiff's lawyers would be able to stand up and say, hey, be careful how you answer this question because it could control or it could affect your general verdict here. And we believe under those circumstances that it's unlikely that there would ever be any inconsistency again, because the jury would be advised of the inconsistency. So that's why we say that the bill, even as amended, would effectively eliminate special interrogatories. The Supreme Court has recognized in the Sommese case, S-O-M-M-E-S-E, that this, by telling the jury you effectively eliminate the significance of special interrogatories, and it's very prejudicial to the defendant, and they ordered a new trial in that case where the plaintiff's lawyer had talked about the effect of the special interrogatory. But nevertheless, the trial lawyers are going to put that into the statute and proceed with it from there. This bill has passed the House. It's in Senate committee this week. It too is likely to pass, this time in the Senate, and be sent to the governor. And we expect the governor, with his relationship with the trial lawyers and with Democratic leadership in the House and the Senate, will likely sign that bill too. But we will continue to work in opposition to that. We have testified against these bills, Senate Bill 1596 and House Bill 2233, in committees, and we have and will talk to the governor's office about them. One more bill, House Bill 2472, is the third ITLA bill. This bill, right now, the law says that acts and services authorized by a regulatory body and products liability cases are exempt from the Consumer Fraud and Deceptive Trade Practices Act, or Deceptive Business Practices Act. This bill would remove that exemption and allow those types of cases to be brought under the Consumer Fraud Act. That, of course, would open them up to attorney's fees for the attorneys in those cases. That bill has passed the House, and it's in Senate committee this week, and it will also likely pass, and again, will likely be signed by the governor. The last bill I want to talk about is our bill, the Illinois Defense Council bill, Senate Bill 1433. This is the bill that has two provisions. It would require that all tortfeasors be placed on the defendant's jury verdict, or that one jury verdict be used for the plaintiff and the defendant, so that all tortfeasors could be considered. This is the way it is in the plaintiff's calculation as to whether or not their fault is greater than 50%. It's not how it currently is in the calculation of the defendant's fault as to whether or not it's 25% or greater, meaning there would be joint liability. So, and right now the jury is told about the plaintiff's, the finding of 51% liability, meaning a plaintiff is barred, but they're not told anything about the 26% or 25 or greater percent liability for the defendant, causing joint liability. This would remove, not only would it allow tortfeasors on the verdict, but it would remove telling the jury anything about the impact of their findings. It would allow the jury to find the facts and the court to apply the law. That bill has not gone anywhere yet. Several members of the Executive Committee and the Legislative Committee met with Senator Sen Cullerton, the Senate President, on May 26th during the IDC meeting, on March 26th, during the IDC board meeting here in Springfield. And Senator Cullerton indicated to us that he was hopeful that we would have a hearing on that bill in this session, so it will be in May sometime if we can proceed with that hearing. It may be even just a subject matter only hearing, which means we would just get to air the merits of the bill. There would be no vote taken, so there would be no likelihood it would pass. But frankly, in this climate in the legislature, there's probably no likelihood it would pass anyway, no matter how good it is, because we are fighting an uphill battle against the plaintiffs' lawyers and labor at this point in the legislature. So we just want to bring you up to date on those bills. We'll do another video and update the video, if not before the end of the session, certainly after the end of May when the session is over. We may do one in the meantime to keep you advised. But if you have any questions, let us know. These bills are all included in the advocacy section of the IDC website, or you can call us and let us know, and we'll be glad to try to help you figure it out. Thank you very much.